What's up, guys? Brian Fell, Law Group PLLC here with your Florida Law Weekly Case Update. First of all, there's a few changes to the rules. When you're filing a motion to vacate a recommended order of a general magistrate, you now have 15 days to do it instead of 10, so you got 5 extra days. Also, when the court is considering a motion to vacate a recommended order, it's going to treat it the same way as a motion for rehearing under 12.530. So that may have implications as far as filing an appeal and whether something is stayed pending resolution of your motion to vacate the recommended order. So keep that in mind. It may depend on whether it's a final order and things like that, but it's going to be interpreted the same way. Finally, the rules are amended so that in domestic violence cases or cases involving domestic violence, the court does not have to refer the case to mediation. And in fact, the parties are required to inform the court if there are any domestic violence issues when the court's considering whether to refer the case to mediation. As far as the case law updates, there's a couple interesting cases on personal goodwill. This is out of the 5th DCA. This is probably going to go up to the Florida Supreme Court. Two different cases. They involve the exact same medical practice. Two different doctors that were getting divorced. One got divorced a while ago. One is getting divorced now. And it really came down to how are we going to value the personal goodwill of this medical practice. The medical practice consisted of multiple doctors. It's not a solo practitioner like the Thompson cases and its progeny. Multiple doctors. So how do you value the personal goodwill? The first case was Conde-Berrocal versus Conde, and in that case, one of the parties was arguing that the personal goodwill should basically be the value of a non-compete agreement. How much did they pay this doctor for this non-compete agreement? The court actually rejected that. The other side had an interesting valuation method. I won't get into the specifics of it, but basically the court rejected the idea that it was solely the value of the non-compete agreement. It had to do with other things as well. The other case that is perhaps more important is Rosenberg versus Rosenberg. In this case, the 5th DCA actually certified a question to the Florida Supreme Court. The question is, when you're discussing personal goodwill of a multi-member medical practice or probably a multi-partner law firm, something like that, do you exclude the total personal goodwill of all the different partners in the firm or all the different doctors in the medical practice, or is it solely the divorcing spouse's personal goodwill, their own percentage of personal goodwill? Well, the 5th DCA actually took the approach to essentially exclude all of the personal goodwill of all the collective doctors, not just the doctor that was getting divorced. But they said, look, there's no case on point. The cases on point that talk about personal goodwill, those have to do with solo practitioners, so it's a little different. So they certified the question to the Florida Supreme Court. So watch for this case, Rosenberg versus Rosenberg. I think it's going to be decided by the Supreme Court. We'll see. The next case is Malley versus Malley. This has to do with time sharing, and it has to do with whether you can refer a case essentially to like a doctor or a guardian ad litem or something like that in order to make the determination of when this person gets increased time sharing. You cannot do that. The court says you cannot delegate authority to a third party. In this case, it was a doctor. I guess it was the father's doctor, and said, okay, once the father completes these specific steps, then the doctor says, okay, it's okay, you can have your increased time sharing. Then he can have the time sharing. No, that gave too much authority to the doctor, to a third party. The authority to increase time sharing in this situation upon completion of tasks or education, something like that, that's exclusively in the court's jurisdiction. The court is who makes that determination, not any third parties. The court cannot delegate its authority to third parties. And finally, the last case is Whitacre versus Ragan, and this was interesting to me because it was essentially a hearing on whether to get rid of time sharing restrictions on an emergency basis. And so what the trial court did there was they held a hearing, but they said basically, Mom, you can't include your witnesses. The mom wanted to include like the teachers and things like that to see what was in the best interest of the children as far as removing these time sharing restrictions. This was like an emergency time sharing restrictions kind of a thing. And the court said, well, no, it's not It's not about, well, can we remove the time sharing restrictions and see if there's no longer an emergency? That's what the father was saying. Okay, there's no longer an emergency, so we no longer need these emergency time sharing restrictions. The appellate court said, no, you still have to consider all the best interests of the child. So the mom is permitted to have evidence of the best interest of the child, even if it doesn't have to do with the basis for the emergency time sharing restrictions. The mom was still permitted to have all of her evidence regarding the best interest of the child, the best interest of the children. So that was reversed for violation of the mom's, essentially the violation of the mom's due process, and also because they applied the wrong standard. Still, in any sort of time sharing consideration, the bottom line standard is best interest of the child. It's not necessarily, okay, how do we get rid of this emergency situation? It's still got to consider the overall best interest of the child. All right, guys, that's it for this week. Hope you guys enjoyed this, and I'll be back next week. Have a good weekend, everybody. Bye.